So, taking a look at other news now at this hour, we've seen that a full bench in the Gauteng High Court in Johannesburg has refused a group of refugees' application to amend the relief they seek in a case over the rights of an asylum seeker. So the group sought an amendment of an order to set aside the decision of Home Affairs immigration officers following their good cause interviews, which were not successful. The application was opposed by the National Prosecuting Authority, the NPA, arguing that it was premature and that the core question before the full court today is the clarification needed on undocumented detained migrants who show an intention to apply for asylum. Counsel on behalf of the NPA advocate Hepzibah Raja.
When the SAPS arrests an illegal immigrant in terms of Section 49(1), and that individual says, I want to apply for asylum. The question whether they should be released for them to be able to go and apply for asylum, or whether the process that is currently being followed by the NPA in collaboration with the NDPP, with Home Affairs, as well as the prosecutors actually, as well as DSD, where human trafficking, where there are concerns of human trafficking. That issue is an issue that this court needs to bring clarification to.
Immigration law expert Ashraf Essop now joins us via video link to chat about the white paper on citizenship, immigration and refugee protection at large. Ashraf, good afternoon and thank you for your time with us here on the SABC.
Hi, good afternoon. Thanks for the invitation.
With the case explored just before we brought you into this conversation, with a full bench in the Gauteng High Court in Johannesburg is hearing the case, after having refused a group of refugees' application to amend the relief that they seek in a case over the rights of an asylum seeker. Help us understand this. The applicants are seeking clarity on the role of the legal authority of Home Affairs, the minister and the officials to detain undocumented foreigners who have, put forth the intention to apply for asylum. And, how does this all work? Does one need to merely express an intention? Help us understand in relation to the case at hand.
Certainly. So this is not a new case. In terms of the facts, these matters have been decided long ago in the Constitutional Court. I would refer to the case of Ruta versus the Minister of Home Affairs, when Cameron, as he was a Constitutional Court judge, and he made a very important assessment in this case. And he says, look, the question is, should an illegal foreigner who claims to be a refugee and expresses an intention to apply for asylum, should he be permitted to do so in terms of the Refugee Act, or is he to be dealt with under the Immigrations Act? And the court said, no, he's to be dealt with in terms of the Refugees Act. But now, remember that this was before the amendment in February of this year, in which the court also considered some of these facts. But I think the resounding question has already been answered. And that is, even if you are illegal or you've delayed, and a considerable delay, and let's say that your application has got untruths and, does that prevent you, and this is the important question, does that prevent you from applying for asylum? And I think the courts have also been unequivocal and said absolutely not. It went further. It says the department officials have a duty to ensure that the applicants are not statutorily excluded, and they must be given every reasonable opportunity to apply for this refugee status. And they refer to the Abdi case in the Supreme Court of Appeals. In that case, the department said, no, they must apply at the first available opportunity, which is the indication of the intention to apply as soon as they are given that opportunity. And the court said, no, I reject that completely. Every reasonable opportunity, according to the standards of Abdi, was reaffirmed. And here's what it means. It follows that once an intention to apply for asylum was evinced, then the protective provisions of the Refugee Act and regulations come into play, and the asylum seeker is entitled as of right to be free, subject to the provisions of the Act. And that was held in the Bula case. So you can see that the courts have been very, very unequivocal about the opportunity and the protection granted to a potential asylum seeker. Of course, we have the case of Ashebo, which was early on this year, and basically the question there was, in light of the amendment to the Refugees Act, both in terms of Section 21A and the Regulation 81A, and there the court said there he needs to apply for refugee status within the 5-day period, and it must be made in person. So again, the question that pops up, okay, if you couldn't make it in the 5-day period, are you precluded from doing so? I've already given the authority in the Constitutional Court as well as the Supreme Court of Appeal that says absolutely not, because then you are protected by other sections, such as the freedom of not being arrested, freedom of person in terms of Section 12(1) of the Constitution, and very, very importantly, the principle of non-refoulement.
Well, Ashraf, thank you. Thank you for helping us understand that case a little bit further. I actually want to now bring in the issue of the white paper on citizenship, immigration and refugee protection as well. And from your vantage point, just calls by the Minister for an overhaul of the migration system in South Africa, calls for South Africa to press the reset button of sorts when it comes to international agreements as well. How would you weigh in on that? And do you think it actually improves our immigration policy as it stands?
You know, in many ways, one is akin to thinking of putting an elastoplast on an amputated limb. There is just so many challenges. Here in the white paper, the minister seems to take a number of international examples for him to justify why we need to amend our, let's say, treaties or our agreements with these international organizations. For example, he speaks of migrants being not allowed to participate in the economy. Some of them have to be housed in detention camps, etc., etc. I think the difficulty that the minister faces is ours is a unique constitution in the world. It's extremely wide and generous. And whatever legislation you intend to bring must fit the constitutional order of the day. And every person, including government, has to respect the Bill of Rights, which is the cornerstone of democracy. And the Bill of Rights contains very, very important rights, such as the right of equality, the right not to be discriminated against, the right to freedom, the right to psychological integrity. So there are a whole lot of competing interests which have to be measured not against the international standard, but certainly against the Constitution. And I think there is a lot of room for debate as to whether these amended intentions to amend is going to fit the bill. Very importantly, the minister has called for input, and you have until January in which to do so. And I would urge civil society as well as individuals to put their contentions forward, because that fits the rule of law and democracy, in that he is giving an opportunity for the public to participate.
Ashraf, thank you for that. What impressions then are reinforced by the minister through what has been proposed? In the same breath, does government take accountability? Is it a smokescreen of sorts to hide behind government failures? Given the timing of this, as we edge closer to elections, are they being used as political lambs for slaughter? I'm speaking about foreign nationals, refugees and immigrants. What are you observing on that front?
So, I mean, to be fair, these amendments were creeping in since 2017. So I don't think it's a Johnny-come-lately attitude to immigration reform. I think there are real problems, because even the department is contending that 9 out of 10 applications for asylum is based on economic difficulties and migrations, more than one of the 4 categories that you're fleeing internal or external aggression in your country of origin. The Refugee Act is very, very clear on what basis you can apply for asylum. I also appreciate what the minister is saying, that the department is completely overwhelmed. And a good example was prior to the ZEP that came into being, 14 years ago. And this is exactly what had happened. Asylum seeking was overrun. and they had to create a special dispensation to deal with these large numbers of persons from our neighboring countries. So you can see there's multiple challenges here. On whether the approach to such reform is correct or not is a different question altogether. You know, there are three different acts here. There's the Refugee Act, there's the Immigration Act, and Citizenship Act. Citizenship is protected in the Constitution. It can't just be removed or amended, you know, without the majority in Parliament having to do so. But I think very interestingly, I think he's trying to zero in on the pathways from refugee permits to permanent residence to citizenship. I think that is one pathway that he's particularly trying to address. The other one, as you would imagine, was the ease in which the minister says people in a relationship with a South African citizen or permanent resident are allowed to migrate towards citizenship in the end. And he says that, look, there is some kind of indication that a lot of these are through marriages of convenience and false marriages. But I don't think, you can take a sledgehammer to swat a fly, if I can use that example.
Well, Ashraf, thank you for those sentiments, because, if we flip the script, we also look at some of the benefits that could possibly also come as a result. How the mobility and immigration schemes, in fact, can meet the skill gaps, promote investment and create jobs across the region. But that's a conversation for another day. Thank you for your time with us on the SABC at this hour and for weighing in. Ashraf Essop is an immigration law expert weighing in just on the white paper on citizenship, immigration and refugee protection. That obviously open for comments, and we'll continue to monitor developments from here on too.